We move now to item number 18 on the agenda, which is a motion regarding report of the Joint Committee on Agriculture, Food and the Marine entitled Detailed Scrutiny of the Island Fisheries Heritage Licence Bill 2017. Deputy Pringle, I understand you're moving the motion and addressing the House.
Thanks, Corla. I move that All Ireland shall consider the report of the Joint Committee on Agriculture, Food and the Marine entitled Detailed Scrutiny of the Island Fisheries Heritage Bill 2017, copies of which were laid before Dáil Éireann on the 8th of November 2018. As a member of the Joint Committee on Agriculture, Food and the Marine, I welcome this opportunity to open the debate on this report. And I have to say that because the Chairman, Deputy Pat Deering, was unable to attend, and as Deputy Martin Kenny, who is actually put forward the bill, is no longer a member of the committee, he can't do the opening remarks either as well, so it fell down to me, Minister. So, and I'll actually I'll take it happily anyway. So, but look. In 2014, the Joint Subcommittee on Fisheries of the then Joint Committee on Agriculture, Food and Marine examined the challenges for coastal and island fisheries. In its report, Promoting Sustainable Rural, Coastal and Island Communities in 2014, the subcommittee made the following recommendation: that the Government examine the feasibility of heritage licences to be issued by the Department for Rural, Coastal and Island Fishing Communities. That's recommendation number 10. Following on from recommendation 10 on this report, the Island Fisheries Heritage Licence Bill 2017 was initiated in Dáil Éireann for the first stage by Deputies Martin Ferris, Martin Kenny and Pearse Doherty on the 12th of July 2017. The bill was read a second time on the 1st of February 2018 and was referred to the Joint Committee on Agriculture, Food and the Marine. As part of its work programme, the committee decided to undertake a detailed scrutiny of this bill. The objective of the bill is to provide a heritage licence to fishermen based on the islands who use traditional and/or small-sized methods for fishing, so that they may fish in shore waters. This supports island communities through the provision of an income stream through fishing. One specific action is sought: a small allocation of quota to be set aside for fishermen who are resident on offshore islands. It is envisaged that this allocation will be in the region of 0.5 to 1% of the overall quota for the country. The proposed mechanism is a heritage licence, which would entitle its holder to access this additional quota. To hold a heritage licence, one must already be licensed to fish as per the current regulations. The committee decided at its meeting on the 17th of April 2018 to seek a number of submissions from interested parties and had public hearings in order to explore the relevant issues and possible solutions on the 1st of May 2018 and the 12th of June 2018. During these hearings, the committee engaged with the sponsors of the bill, department officials, 7 fisheries organisations and academics. And I would like to thank all those who appeared before the committee and submitted evidence for their valuable insight and engagement on the topic. I would now like to talk through some of the specific issues and key recommendations within the report. In concluding its detailed scrutiny of the Island Fisheries Heritage Licence Bill, the committee recommended the following: that consideration be given to renaming the proposed heritage licence. The committee suggests that naming the instrument a Heritage Fishing Opportunity Licence may be more appropriate. That an allocation of 0.5 to 1% of the national quota be set aside for heritage and traditional fishing, which can only be accessed through holding a HFOL. That consideration is given to further detail regarding appeals procedures, review processes and provision for offences, sanctions or enforcement powers. These points may be addressed by incorporating these aspects of the HFOL into the current licensing system, recognising it as an additional instrument intended to follow access to additional quota. Noting recommendation 10 of the 2014 Joint Subcommittee on Fisheries report that the HFOL be introduced for island communities on a pilot basis. That consideration be given to expanding the scope of the bill to include certain coastal communities that experience particular disadvantages as well. That the requirement for a vessel to be licensed and entered in the polyvalent register is continued. This protects the integrity of the register and the safety of the fleet. That provision be made for requirements that relate to track record can be set aside for quotas allocated under the HFOL, but that similar requirements for ordinary quota remain in place. That provision be made to allow for the transfer of the right to avail or benefit of a HFOL between a number of named beneficiaries who are fishers who use the same licensed vessel. The committee considered 4 categories of policy implications in this report: environmental, economic, social and legal. And the committee recommended the following: that the current system for allocating quota is reviewed and evaluated in terms of the economic benefit of every fisher with a registered and licensed vessel. In particular, the committee believes that a system where there is an imbalance in quota allocation must be avoided. That consideration be given to placing a structure in place to ensure specific issues may be addressed at a higher level, and that the need for consensus on issues at the regional inland fisheries forums level be reviewed and to account for island-specific issues. That consideration be given to cross-sectoral study of island communities in order to understand the overall losses to island communities, not just in terms of population and economic opportunity, but also in terms of cultural impacts and opportunities for sectors such as tourism and infrastructure. In conclusion, the committee acknowledged that the bill has significant potential to improve the lives of island fishers, and that there is scope for expansion to coastal fishers in extremely disadvantaged coastal regions, rural coastal fishers. The committee also acknowledges that the traditional fishing sector has less of an impact on the marine environment, and supporting this should be encouraged. However, the bill should have due regard to the limits set by quotas under the CFP and suggests that additional quota allocations for islanders pursuant to existing initiatives be explored. The committee believes that its recommendations provide a pathway for aligning the bill with the overall policy objectives for fishers at a European and national level, as well as making some suggestions on how the wider policy framework for fisheries in Ireland can be improved to provide additional supports for island fishermen. However, some wider questions remain as to the method of allocation of quota and the requirements in terms of licensing and capacity. The committee notes that the Department held a public consultation in April 2018 in relation to the issue of trawling activities inside the 6-mile nautical limit, and the committee reviewed the correspondence from the Minister in January 2019, informing the committee that following this process all trawling activity by vessels over 18 metres inside the 6-mile nautical limit will end from the beginning of 2022. On completion, January 2020. Sorry. So I take that correction as a typo here in the committee. On completion of its detailed scrutiny of the Island Fishery Heritage Bill 2017, the committee recommended that this bill progress to the third stage, provided the scope is clarified to ensure that the island and rural coastal communities are appropriately balanced. Chairman, that's just the official report from the committee itself, and I'd like to just add some of my own comments in relation to how things have progressed since then, because I think it is a very important issue, and I know that the Minister and the Department has a particular view in relation to the Heritage Licence and the Heritage Licence Bill, and particularly that it may require a money message from his department. And I have to say, and having looked at the details and the reasons for the money message, I think it's an excuse to block the bill rather than an actual need for a money message, and that's a separate issue that's debated widely in this House anyway. But I think it is significant. And the island communities have worked very hard to try and sustain their livelihoods and to sustain life on the islands, and the islands is very difficult to survive there, and what we should be doing as a nation and as a state is making sure that the island life and island community and basically traditional island life is made as easy as possible and as easy as can be under the difficult circumstances we have to do. Because in reality, the success of us as a nation will be how we treat people that are not have the same advantages as people who live in Dublin and living in D4 and everything else and that there. And we have to treat our traditional methods of fishing, traditional methods of life in a way that respects them and allows them to progress and to provide a livelihood for themselves and their families on the islands. I'm sure the Minister would agree that life on an island is difficult enough without having to fight constantly against the officialdom within the country to ensure that you can survive. And fishermen have constantly battled, and they probably haven't been as effective as the farmers in terms of making their case and fighting their case and over the livelihood of this country, and then the fishermen are diverse as well, and the island fishermen are probably the weakest sector in terms of the whole fishing community, and they need to be defended. And I think we need to be ensuring that they can survive and they can continue to work at what is a traditional method. And when you look at the island communities, I think, landed 0.85% of our national quota in 2018. That's a minuscule amount. And, and maybe by increasing their quota allocation to maybe 1.5% of the national quota, it will make absolutely no difference to the larger fishermen, but it will make the difference between communities dying and communities surviving for island communities, and I think that's as well worth doing and well worth pursuing. And I must say that the IIMRO, the Island Fisheries Producer Organisation, have done a lot of work in the meantime as well to try and ensure that they can survive and they can continue. And they have met a lot of the grounds or tried to meet a lot of the grounds that the Department has put before them in terms of how they be a producer organisation and how they can be recognised under the fisheries requirements that the Department has. And really and truly what has ended up, they've hit a brick wall, because one of the criteria that the Department has said that is a mandatory criteria for recognition of them is that 30% by weight of the total production should be landed into a major port across the country. Now, that's fair enough if it's actually there, but from what they have said and all that they have done in terms of trying to meet this, they have never come across that 30% requirement anywhere, and it was introduced as being at the last stage when they actually thought that they were getting places. And I think that is a problem. And Minister, and yourself and your department officials will say, well, the last thing we need is another producer organisation in Ireland that we have to deal with. But the reality is that this would be a producer organisation that is working on behalf of the fishermen that they represent. And some of the producer organisations are that big, and there's so many different sectors within it that they don't speak with one voice. But this would be speaking with one voice, and I think it would be vitally important, and it's beholden on us as a DAL and us as a government and us as a department to facilitate people as much as possible, and I think that's where we should be going down the road. And I would ask, Minister, that you would consider after today's debate and that actually meeting with the Island Fisheries Organisation themselves to explain just the criteria that they have. They've gone a lot of the way to try and meet all the requirements. They might be able to go the rest of the way, and if you would meet with them and explain to them, maybe that might go some way towards actually progressing as well, and I think that's vitally important. Thank you.
I welcome the opportunity to speak on this matter, the committee's report on the Island Fisheries Heritage Licence Bill 2017. I want to reassure the House that both I, as Minister for Agriculture, Food and the Marine, and the Government recognise the value and importance of maintaining vibrant rural, island and coastal communities. This was in fact the motivation for the Action Plan for Rural Development, Realising Our Rural Potential, which was launched in January 2017 as a whole-of-government strategy aimed at delivering real change for people living and working in rural Ireland. More recently, the Government Whip, Sean Kine, who is tasked with responsibility for Gaeltacht and the islands, has been asked to assist with the formulation of a national islands policy. And to that end, Minister Kine has already established an interdepartmental committee to identify the key stakeholders and to prepare a consultation paper to provide a framework for the development of the policy. In relation to the Island Fisheries Heritage Bill, it is already a matter of record that the Government is opposed to this bill due to its incompatibility with existing European Union legislation, namely the Common Fisheries Policy Regulations. The current sea fishing boat licensing legislation and procedures already allow residents of Ireland's offshore islands to enter the fishing fleet in the same manner as any other applicant. The European Union regulation does not allow for a scheme of sea fishing licences for individuals separated from the commercial sea fishing boat, as proposed in the bill. In April this year, I wrote to the committee chairman and to Deputy Kinney to advise them of the Government's reasoned response to a request for a money message for this private member's bill. For the benefit of those present in the chamber, I will read the letter into the record. Dear Martin, on the 2nd of April 2019, the Government approved a reasoned response to the request for a money message in relation to the Island Fisheries Heritage Licence Bill 2017. The reasoned response, of which there was a copy attached, sets out why a money message should not be issued for this legislation and includes 1. The bill is not compatible with existing European Union legislation, namely the Common Fisheries Policy Regulation and related regulations. 2. The recent policy directive 1 of 2019 introduces restrictions on the trawling activities by fishing vessels over 18 metres in length overall inside Ireland's 6 nautical mile limit, and is expected to improve fishing opportunities for smaller vessels. And 3, as outlined in my letter to you on the 31st of January 2019, improvements have been made in the communication of quota availability to the inshore sector. A further recent development in terms of small-scale fishing activities is the launch of the Inshore Fisheries Strategy, which was developed by the National Inshore Fisheries Forum in partnership with my department, BIM, the Sea Fisheries Protection Authority and the Marine Institute. I hope that the implementation of the strategy will lead to further sustainable development of the small-scale inshore sector, and in this context I have asked BIM to work closely with the National Inshore Fisheries Forum to deliver the objectives set out in their strategy. Finally, I continue to encourage any inshore fishermen and fisherwomen, islanders or otherwise, to work through their regional inshore fisheries fora to develop, advance or influence policies they feel can contribute to their inshore fisheries communities, yours, etc. The reasoned response was laid before the House, so I will not read that now. In a previous letter on the 31st of January 2019, I advised Deputy Kinney of policy developments of relevance to the rationale being used for this bill. I will also read this letter in also. Dear Martin, I am writing to you in relation to policy developments concerning fisheries management, and particularly how these address issues which the Private Members Bill, Island Fisheries Heritage Licence Bill 2017, appears to have been influenced by. On the 21st of December 2018, I announced the outcome of a review of trawling activities by fishing vessels inside Ireland's 6 nautical mile limit, which has culminated in the decision to restrict trawling activity by vessels over 18 metres in length overall within this zone. By way of background, in April 2018, I launched a public consultation on the issue of trawling activities inside the 6 nautical mile limit. This consultation followed initial analysis of this issue by both the Marine Institute and BIM, and also preliminary feedback from the fishing producer organisation. The consultation document put forward 3 potential options in light of the initial analysis. There was a wide diversity of views expressed in the approximately 900 submissions received, and all of the submissions are available on the department's website. The BIM analysis highlighted that the exclusion of trawlers over 18 metres in length would likely lead to a reduction of 2.6%, approximately €5.5 million, of their overall landings. I make that observation in the context of the point made by Deputy Pringle about increasing the quota from under 1% even to 1.5%. So this initiative is getting to 2.6%. This small proportion of landings being foregone by larger vessels will provide opportunities to smaller inshore and island fishermen, which would represent a potential increase of 62% in the value of their landings. I recognise, of course, that this potential figure may not be fully realised by the smaller vessels, but the percentage gains for those vessels that will take up these opportunities will be significant. Additionally, the increase in availability of sprat and herring to smaller vessels would represent a diversification opportunity, as these species are found in bays and coastal areas during the winter. The Marine Institute report identified that trawling by large vessels can have a more detrimental impact on the environment than smaller trawls. Coastal waters provide nursery grounds for a number of commercial fish species, and mixed species trawls can capture higher proportions of smaller fish inshore. Thus, the new measures will provide additional protection for those nurseries. The National Inshore Fisheries Forum made a submission on the proposals during the public consultation process. The National Inshore Fisheries Forum is the representative body for the inshore fleet and is supported by a network of regional inshore fisheries forums. Island groups are among the multiple stakeholders represented on the forums, including at national level. The national submission by the Fisheries Forum was in favour of the option which has been approved to exclude vessels over 18 metres using trawls. I believe that a compelling case for excluding trawling by large vessels in coastal waters inside 6 nautical miles has been made. I am of the view that there are enough opportunities for vessels over 18 metres outside of the 6 nautical mile zone. For just over 1% of these vessels, sprat constitutes a high proportion of the value of their landings. For this reason, over 18-metre vessels will continue to be allowed to trawl for sprat only inside the 6 nautical miles until 2022. This phased process addresses the transitional period required by those vessels to adapt, and I've asked BIM to work with the vessel owners and others towards a smooth transition. A total allowable catch of up to 2,000 tonnes, reflecting a reduction on recent years, will be permitted for these vessels during 2020, reducing to 1,000 tonnes in 2021. All trawling activities by vessels over 18 metres inside the 6 nautical miles limit will end from the beginning of 2022. I am convinced that these measures will provide further sustainable development of the small-scale inshore sector, which the Government committed to in its programme for a partnership government. My officials have advised that a further key issue which emerged during consideration of the bill related to the communication about the opportunities which exist for inshore and island fishers to exploit quota-controlled stocks. I understand that this has also been addressed through the provision of figures on quota availability and fleet policies to the inshore fisheries forums. The National Inshore Fisheries Forum has a representative on the Quota Management Advisory Committee, and I continue to encourage inshore groups to seek updates through the Inshore Fisheries Forum so that the messages about quota availability continue to be disseminated throughout the industry. In relation to the Island Fisheries Heritage Licence Bill itself and the Joint Committee report on the matter, it is worth noting that the restrictions on trawling by vessels over 18 metres will benefit all coastal inshore fishers, whether island-based or not. This is, I believe, in the same spirit as the Joint Committee's suggestion to extend the concept of a heritage licence beyond just islanders. Another important issue I feel needs to be addressed is the concept of a specific licence being envisaged to assign quota opportunities. This is not the current practice for quota management, and the Sea Fisheries and Maritime Jurisdiction Act of 2006 already provides regulatory tools in the form of notices and authorisations, which are actively used to manage opportunities to take up quota across the fleet at present. Introducing an additional licence for this purpose may prove counterproductive to adaptive quota management and transferring opportunities between eligible fishing vessels. I trust from the foregoing that it can be seen that many of the issues which gave rise to the aforementioned private members' bill have been addressed. You may wish to reflect on whether or not to continue with the legislative process in view of these developments, etc. Now, I am a firm believer, Ceann Comhairle, in getting stakeholders involved in the development of measures that will affect their sector. It is for this reason that I meet regularly with industry representatives from the various sectors my department works with, including the fishing industry. The National Inshore Fisheries Forum and Regional Inshore Fisheries Forums were established to develop and facilitate implementation of policies and initiatives relating to the sustainable management of those fisheries. The Regional Forum members include inshore fishermen, environmental interests, marine leisure, marine tourism and other marine stakeholders, including islander interests. In February of this year, I was very pleased to launch the first industry-led strategy for the inshore sector. The strategy for the inshore fisheries sector 2019 to 2023 sets out a vision for the future of the inshore sector that it, and I quote, will have a prosperous and sustainable future delivered through a united industry with a strong and influential voice. Key issues to be addressed through the strategy include enhancing business skills across the sector, sustainable management of fish stocks, as well as attracting and retaining talent, all with a view to maximising the potential of the inshore sector to support Ireland's coastal communities. Inshore fishing boats currently make up more than 80% of the Irish fishing fleet and support an estimated 2,500 to 3,000 jobs. This economic activity is vitally important to the coastal communities around Ireland, including the island communities from which these boats operate. The national and regional forums are supporting initiatives that seek to protect the collective interests of the inshore sector in Ireland, including on our islands. The National Forum, the NIF, has been very effective in its participation on the Quota Management Advisory Committee, advocating on behalf of small-scale fishers to influence how Ireland's uptake of quota is achieved. To turn to the matter of the Joint Committee Detailed Scrutiny report, one of the recommendations is to extend the notional licence to others in coastal communities experiencing disadvantage. The existing system is already established in national legislation and reflects EU requirements under the Common Fisheries Policy for each member state to licence all commercial sea fishing boats, small scale or otherwise, and to maintain its fleet within certain limits. The licence system proposed in the bill would apply to small scale coastal fishing, a narrow subset of fishing which can only be undertaken in vessels of less than 12 metres overall length and which must not use towed gear. Small-scale coastal fishing is commercial sea fishing and is already regulated in that context. There is also quota already available for a number of relevant species to licensed fishermen using smaller fishing boats. Communication on the availability of these opportunities has been improved, and the representative body, the National Inshore Fisheries Forum, is now involved in the Quota Management Advisory Committee, which makes recommendations to me on the uptake of the state's fishing opportunities. I would like to stress that the existing legislation in this area provides an independent licensing process for sea fishing boats and contributes to managing Ireland's fishing fleet within the European Union rules. The existing legislation and procedures are available and apply to islanders already. If the bill did progress and licences were issued to individuals to operate in parallel to the existing system, to walk onto various vessels and bring mobile separate entitlements, this would present a significant challenge to Ireland in demonstrating compliance with various common fisheries policy regulations. Article 16 of the Common Fisheries Policy Regulation explicitly requires Ireland as a member state to manage its fishing opportunities in the context of allocations to vessels flying its flag. This is a serious responsibility for Ireland to manage carefully and responsibly, particularly in the interest of achieving maximum sustainable yield for the stocks under quota management. I do also believe it would impact on the principle which has been part of the common fisheries policy since its foundation here, of quotas being a state rather than a private asset. And I think that's a point worth reflecting on, Deputies. In conclusion, I will say again the Government cannot support this bill because it is not compatible with the Common Fisheries Policy regulations. The bill is well-intentioned, and I do appreciate Deputies Kenny's initiative here, and it has focused a debate on a sector that I think was long excluded from broad fishing consultation, and with the development of the NIF and the regional fora and the exclusion of people outside of the inshore sector now for large boats, I think that is all a positive. The Government is committed to implementing meaningful and supportive policies which accurately reflect the needs of island communities. I have already set out the improvements in communication and engagement on the fishing quotas and the significant policy changes that demonstrate that this Government is responsive to those needs and to the needs of island communities. Thank you,
Mr. Creed. Deputy Willie Penrose, please.
Thank you, Conor. And I'm glad that we have the Labour Party to avail this opportunity to contribute once again to the Island Fisheries Heritage Licence Bill. This year as a private member bill by Deputy Kenny, among others, here in 2017. I say at the outset that we in the Labour Party unequivocally supported that at second stage here, not just in terms of the objectives of the bill, but the underlying sentiments surrounding the amended bill even that has been scrutinised by the committee of which I'm a member. And we've now reached the stage where we have the report emanating from the Joint Committee presented by Deputy Pringle here this evening, pertaining to a focus on detailed scrutiny of the bill. I made my own views on that the Labour Party know under the course of the second stage debate here in the Dáil prior to its referral to the Joint Committee for detailed scrutiny, and I wish to endorse in all the sentiments I revealed at that stage. I must reiterate that the overall aim and thrust of the bill, which is essentially to facilitate the continuation of traditional fishing on Ireland's offshore islands, and thereby fundamentally provide for sustainable fishing communities in the islands for the future. And the licence, in my opinion, would help to achieve sustainability by reversing the population trend, which is evident, one of decline, and sustain many of the offshore islands. The Government has already indicated, and Minister Creed has reiterated again here this evening, that the legal advice is that the bill is not compatible with EU law provisions or indeed a common fisheries policy, and that it is in fact inoperable in its current manifestation. They have also, of course, reached once again for what is now fast becoming a discredited use of the money message, but Minister Creed did not refer to it this evening. And that is difficult to fathom as to how it might apply in the context of this bill. Indeed, the reverse of the request to expend money would be likely to arise, as the maintenance of vibrant and sustainable communities would be more than likely to generate additional revenue and resources for the Exchequer. The Government asserts that fishing licences are attached to fishing vessels and not to individuals, and that all the applications for such fishing licences are decided by the Sea Fishery Board Licensing Authority and not the Minister, and that's independence, and I suppose that's fair enough. The genesis of the Sinn Féin bill can be traced to recommendation 10 of the Subcommittee on Fishery Reports 2014, promoting sustainable rural coastal communities, which urged examination of the feasibility of heritage licence to be issued by the Department for Island and Coastal Communities, and which would facilitate fishing practices in conjunction with the establishment of a producer organisation representing smaller fishery vessels in these specific areas. I have read your reasoned response, Minister, to the bill, specifically referred to sections 1 and 2 of the bill, and to the advent of recent policy developments, which it suggests has material bearing on the matter set out in the bill, which you again reiterate here on the floor all this evening. The bill defines small-scale coastal fishing has been carried out by fishing vessels of less than 12 metres length and not using towed gear such as trawls or dredges. Section 2 and subsection 4 of the bill envisages the licence could not be transferable, but in our scrutiny review, correctly in my view, we recommended that provision must be made to enable such licences to be transferred, which would clearly be consistent with the current system applicable to sea fishing boat licence, and that was one of your objections which we dealt with. I have to say, in relation to Section 2, subsection 6 of the bill, which deals with the regulations underpinning a non-transferable island quota, the Committee recommended the allocation of up to 1% of the national quota to be set aside for heritage and traditional fishing, which can only be accessed through one hole in a heritage licence, and which can be when one aboard a licensed sea fishing boat. Article 17 of the Common Fisheries Policy, in my view, enables a member state to formalise support for the islands and ensure a fairer allocation of fishing opportunities. Paragraph 20 of the Fisheries Policy Preamble states, and I quote, "Small offshore islands which are dependent on fishing should, where appropriate, be especially recognised and supported in order to enable them to survive and prosper." The Irish Islands Marine Resource Organisation, or IIMRO, gave some figures to me for 2018, which were obtained independently from the Sea Fisheries Protection Authority Ireland. And they're made for interesting reading, Minister. And I'm not an expert in this area. I know more about the inland fisheries, but I defer to my colleagues here who are more expert. But Ireland's quota uptake of respective vessels under 12 metres in species type demersal and pelagic, and it was less, as Deputy Pringle says, 0.85%. And EU Regulation 1380 of 2013 provides that small offshore islands dependent on fishing be especially recognised and preferential access be given to small-scale fisheries. In other words, empower small-scale fisheries areas. Small-scale fishing is less damaging on the marine environment as these traditional boats do not tow trawls which damage the seabed and don't collect or catch huge quantities, and it could also promote the use of traditional fishing methods which are environmentally sustainable. Fishing families would benefit from higher wages and prices achieved from the new situation, and indeed families would be more likely to remain in the island community all year, resulting in a more vibrant community. And it would assist in keeping traditional ways alive and lead to an increase in the number of tourists to the area, and this would lead to increased spending in the area and better and more sustainable future. You could have all the attractions of local heritage, in relation to this type of fishing, heritage boats and the curraghs, which we all learned about when we were going to school, and you'd have an increase in tourism activity. So there's a huge lot of things that could lead to a viable future. Minister, I wonder why is there always evidence of bureaucratic opposition or resistance to a bill such as this? And every conceivable objection is dredged up to show incompatibility with this regulation or that, or with the application of this system or that, rather than you adopted a more facilitative or a more accommodating mode, which would enable a laudable piece of legislation such as this bill to amend it so as to become the law of the land and help out a group of people who are playing a positive and protective role of our heritage, language and our unique way of life. The Excellent Research Unit of the Library has been of great assistance in helping to identify appropriate international comparisons. Already, obviously, other countries have gone to the trouble of positively devising policy options so as to help sustain small-scale fisheries. Many case studies have used some of these policy options so as to help conserve sustainable local coastal communities. A number of these were detailed in the Grieve 2009 report on environmental and social criteria for allocation and access to fishery resources, three of which are set as follows: the Costa Vadera Fjord in Sweden, the Shetland Islands off Scotland, and the Lisa Marie Reserve in Spain. And in relation to the Costa Vadera Fjord in Sweden, it was Sweden's first national marine protected area, and local trawling have found coexistence. It's part of a government-developed co-management initiative for managing Sweden's indoor fisheries. And under the initiative, continued access to northern shrimp, lobster and northern lobster resources was allocated to a limited number of local fisheries. The Shetland Islands, 150 miles off the coast of Scotland, has traditionally been one of the most fishery-dependent communities in Europe. And in order to protect their wildlife, they developed a community quota scheme which included ring-fence quotas and quota pools. However, in Spain, the marine reserves of fishing interests or marine reserves are protected by fisheries legislation. And Spanish marine reserves are primarily used as fishery management tool, and their primary goal is the enhancement of fishing resources and the maintenance of sustainable, traditional, artisanal fishing in the areas. Over the years, conservation of marine biodiversity in general also became one of the core objectives, but the primary focus remains on fisheries and the protection of those reserves for users outside the senses of traditional artisanal fishermen. And the most widely recognised maritime protection areas in Spain where fishermen are involved in the declaration and implementation of MPAs are in Lira and Cadira, both off the Atlantic coast of Galicia. So, I mean, it can be done, Minister. But I have watched here in 27 years now, starting 28 next week. Every bureaucrat in the place is wheeled out. The definition of a bureaucrat is find a way to block. The definition of somebody who wants to do something is find a way to accommodate and facilitate. And that's our job here. And the Marine Resource Organisation, which Deputy Pringle and those are very familiar with, I mean, they're not fools. This bill is only about allowing access to a small percentage of relevant national fishing quota species to small island boats under 12 metres using non-towed fishing gear within the 6-mile limit. And we have discussed the 6-mile limit ad nauseum here in relation to the London Agreement. Quota uptake for the year 2018 showed, as it says, under 12-metre boats, which make up over 60% of the dairy fleet, landed just 0.85%, as Deputy Pringle says, of the national quota allocated. This access to a small amount of quota will enable the reinstatement of seasonal fishery system around the offshore islands as was practised in the past. Fishers will be required to be aboard their own registered vessel while fishing. Boats will be registered island vessels with appropriate tonnage, kilowatts and a polyvalent general licence. There will be no increase in fishing effort as a result of the bill. And the bill is fully compliant with the requirements of the Common Fishery Policy, and that has been confirmed to them by the EU Commission. So why do your officials go out of the way to contradict what? Why don't you have a round-table forum with the EU Commission, your officials, yourself and those people? And let's see, can we make some progress? And the administrative allocation of a small amount of relevant quota when the existing national quota will not incur any additional cost to the Exchequer, so forget about the money bill. And there are over 2,000 boats and dairy fishing vessels registered in 2018, and there are only 70 boats on the island polyvalent general register. Minister, I rest my case as somebody who comes from the bogland, shall we say, or the heartland of rural Ireland, the Midlands of rural Ireland. I cannot understand why something that I watched on television, that we read in Peg Sayers and all those things, they'll all be lost because of our intransigence. Not our intransigence, but the intransigence of bureaucrats who advise you.
Thank you, Deputy Penrose. Deputy Lawless.
Thank you, Ken Corda, and thank you to Deputy Connolly for letting me in because I'm under the pressure for time. I welcome the report, and my party did support this bill at previous stages. So we support the report again today, and we recognise this as an excellent initiative, an initiative to maintain sustainable traditional fishing methods while, I suppose, facilitating a formula to manage stocks and manage quotas and have minimal interference with the total allowable catch national European rules around same. And I want to commend the committee who prepared the report and Deputy Kenny and Deputy Pringle and the others that were involved in the preparation of it. And indeed my own colleague, Deputy Vilas Cancorla, Deputy Cope Gallagher, has spoken on this subject many times, and there's few certainly I doubt his superior knowledge on the issue, and he recommends highly that we endorse this initiative. We do have some, I suppose, as always, there are some technical amendments that may be tabled if this bill does hopefully proceed to the next stage, if it does get to committee stage, and there are some amendments, and I think all the issues that have been raised, and I listened to the Minister raise a number of concerns, I'm sure they can be tackled at committee stage as always, because where there's a will, there's a way, and I'm sure the way can be found. I do note that the Minister has read into the record a number of letters to the committee and to Deputy Kenny in particular, outlining reasons why a money message may be put forward. I don't necessarily accept those reasons, but I do welcome the fact the Minister actually wrote to the Deputy, because I've introduced many private members' bills which didn't get any letters or responses, indeed from government. So a letter saying no is better than no letter at all. So I commend the Minister for that, and maybe he might ask his colleagues to take up the similar approach on other matters. As Deputy Penrose has spoken about, a deputy from the Midlands, no more than myself, but I think all of us, and Deputy Kenny made this point in previous debates, all of us have an affinity with our coastal communities, with our fishermen, with our traditional ways of life. And indeed, I'm someone who grew up in a coastal community because I grew up in Court on Harbour, County Wexford, where boxes of whelk or periwinkles or even mackerel or bass on occasion were never too far from the house or the home. Or indeed the kitchen table. So my grandfather was very fond of fresh seafood. He ran a hotel in Court on Harbour, so there was certainly it's an industry some familiar as a child, at any rate, if not today. But I think this is important. The fisheries have always been part of Irish, I suppose, our economic importance. Unfortunately, during our session to the EU, and this bill does rotate around quotas and allowable catch, etc., I think it's fair to say that our agricultural sector was protected and preserved and boosted, but at the expense of our fisheries sector. At the time, there was, I think that's common cause. I think that would often be said, and perhaps an undue focus was placed on it at the time, and I suppose with a variety of reasons. I don't know, Minister, in 1976 there was a Fianna Fáil opposition bill tabled to say that the quotas would be revisited and the common fisheries policies would be reviewed. I think in the round it didn't happen, but I think that's often being said. The Law of the Sea, I recommend, Minister, it's an excellent academic work on this subject, and the prelude to that would suggest the same. But I think, as has often been said, and I think there's certainly some truth in it, that our fisheries policy, that our common fisheries policy, when we opened up, considering the size of the seabed and size of the offshore resources available to us, perhaps we didn't quite negotiate as well as we might have done in that regard, but we did a better deal on the agriculture side of it, and maybe there's swings and roundabouts there. We've always had pressure on our stocks. We've always had pressure of the both coming in. But on the flip side, we've always gone out. And indeed, if you listen to people from the coastal communities like Greenland, Labrador, Newfoundland, you'll find Irish accents and dialects and names, and I'm sure DNA if we were to dig deeper, because we've always travelled. And indeed, the story of fishing is a story of migration around the world. It's said when Columbus discovered, or allegedly discovered, America and claimed it for the Kingdom of Spain, he didn't notice, or perhaps he noticed but didn't report home, several Basque fishing boats were already ahead of him in some of the estuaries and have been going there for centuries. But that didn't suit the narrative at the time. So often politics and fishing, and other areas, is subject to the prevailing wisdoms of the day. It's also the case that British colonial policy towards Ireland was to support in ports like Hull, Grimsby and Aberdeen, big industrial scale superports and to bolster their own fishing industry, but at the same time trying to keep the Irish fishing industry weak because they're seen as an economic threat. And part of that was to divide and conquer. And rather than having an investment on scale, it was to support myriad little small jetties and wharves and piers, which weren't really sustainable to take off. And that's something, I suppose, to be mindful of as well. There is a need for economy of scale, but equally there's a need for investment in these matters. I think that the bill before us today, the report before us today, I think it makes a lot of sense. I think it's a way to preserve that kind of coastal tradition, that economic imperative. I think it does need to be carefully phrased and carefully managed. I think some of the debates that have taken place on the committee about how to ensure it's an island resident and how to ensure it's, the various fishing measures are legitimate. I suppose that's it's a reasonable question to ask, but I think there are measures in the bill and have been debated at committee to mitigate that. I think it can be done. I think it should be done, and I don't think it's necessary. I hear the Minister and the officials say that it may be in breach of EU law. I'm not certain, and I'm certain if it is, that the impact is so minimal that it could actually be addressed through committee stage and through amendments. I'm going to leave it there, Corla. Thank you very much.
Thank you, Deputy Lawless. Deputy Catherine Connolly.
And I welcome the opportunity to take part in this debate. And I want to thank my colleague, Deputy Pringle, for outlining the situation and the report from the committee, which I won't repeat. But I just want to put it in perspective because less than, I think, 2 months ago, on the 17th of December, this Dáil passed a motion which I had the privilege of putting in relation to developing a policy for the islands. And you mentioned that tonight, but what you failed to mention, Minister, was the effort that had to go in to get that motion passed, and it was passed. Actually, I can't remember whether you voted with it. It was certainly passed by an overwhelming majority. But it highlighted the absolute lack of policy for islands. That's why we were forced to bring that motion on the 17th December. And in speaking on that night, I pointed out that going back to 1996, a report was published of the Interdepartmental Coordinating Committee on Island Development, a strategic framework for developing the offshore islands of Ireland, and so on. Lots of very good ideas, none of them enacted. Fast forward to 2019, and we have another interdepartmental committee. I mean, I welcome it, but it's certainly not what we wanted, I or my colleagues. And it certainly doesn't have proper representation. In fact, the Minister had an unfortunate use of language when he said, well, actually, we can't have islanders on that interdepartmental committee because maybe people, officials mightn't feel free to talk, which really captures and encapsulates yes, I'm actually quoting Ciancorla in relation to that. That was the statement on the night, that you couldn't have islanders on the committee. And it seems to me that that's a huge problem in officialdom, that we think actually listening to people with ears and then taking on board what they're saying is problematic. And so then tonight you come in and you give us the background, and I've read the recent opinion, and I actually see some of the difficulties in the the bill as it's before me, but they are problems that can be overcome and can be rectified. And the bill is based on a background. I mentioned the original report back in 1996. Then in 2014, we had a detailed report, again setting out recommendations. And Deputy Pringle has referred to recommendation 10 in relation to that we should explore the feasibility of heritage licence to be issued by the Department for rural, coastal and island fishing communities. And Deputy Pringle has pointed out that we're not just focusing on island communities, it's also open, and we would hope to be developed for coastal communities. So that's the background, 2014. Fast forward then, we have another committee looking at this, which Deputy Pringle opened tonight, and the date of that is November 18. So nothing has been done here in a hurry. Everything has been very slow and tortuous, and meantime, the population of the islands is declining, and it's very difficult for people to have hope. And I notice in relation to the committee and the submissions, we had Cogal Ilon Naherden, which is from my side. I come, as you know, from Galway West. I represent Galway West, which is a huge constituency, a huge variation. It includes the 3 Aran Islands and Inishbofin. And so we had somebody from Inishbofin making a presentation, and then we had the Irish Islands Marine Resource Organisation. Again, I recognise both of the names, and one of them is from my constituency on Inisheer. In addition, I see a contribution from Dr. Ruth Brennan, who pointed out the difference between equality and equity and forced me to think about that. So I'm actually hoping that you'll be forced to think about that. What is equality and what is equity? And she gave a very good anecdote in there that explains it. And equity means a lot more than equality. So when we look at the islands, we want to deal with them in an equitable manner. And all that this motion is asking for is that we let the bill go to third stage, to look at the difficulties in the bill, work them out, and in recognition of what the islanders have asked for an extraordinary length of time. Why? Because it is very good for the economy that we have islands that are functioning, that people are living there, and they're on every level that I went into on the last occasion when I was talking about them. For tonight, Minister, it strikes me as a little arrogant that you might talk about the bill being well-intentioned but ill-informed when you tell us it's against. I think perhaps there might be ill information on the government side as well, because EU legislation, and again, I'm only quoting from the committee, and they had the experts in, and so they tell us that recitals 19 and 20 of the Common Fisheries Policy, Regulation 13802/2013, 20 in particular, small offshore islands which are dependent on fishing should, where appropriate, be especially recognised and supported in order to enable them to survive and prosper. And in relation to 19, it's there for you to read, but the last line of it, member states should endeavour to give preferential access for small artisanal or coastal fishermen. So that's that. In addition then, the Irish Islands Marine Resource Organisation very helpfully point out that the Common Fisheries Policy in the preamble, paragraph 20, small offshore islands which are dependent on fishing should, where appropriate, be especially recognised and supported in order to enable them to survive and prosper. And then, equally as helpful, on page 4 of the report, the committee tells us that there are precedents for doing this. And so they point out a number of international case studies for us, where local communities have found ways to sustain their traditional fishing methods. And they mention in particular the Shetland Islands, they mention in particular the Costa region in Sweden, and Lira, and forgive my pronunciation, in Galicia in Spain. So it would appear that the absence of information is on the government side in relation to policy, and a very, very limited interpretation of regulations to suit the fact that we don't want this bill to go through. So I would think something has happened in the sense that we have, you mentioned policy changes. And I welcome those policy changes that has happened in relation to the exclusion of certain boats within the 6 miles. Of course, it begs the question why it took up to now to do that when it could have been done before, in recognition of what fishermen have been saying for a long time. And the second item that you itemised was in relation to communication, and that has improved, which again begs the question as to why communication couldn't have improved many, many years ago. We don't need to go back too far, but certainly back to the 2014 report, where they recommended certain recommendations. So I have no hesitation in supporting the motion here tonight, although I do see problems in the legislation. I did look at the reasoned opinion and read it. However, I think there's a much bigger picture and a challenge to the government to actually make a reality their words. And if we want a sustainable island community, then we want a policy, and we need it urgently. And in the formation of that policy, we need to hear the voices of the islanders. And if they can't sit on an interdepartmental committee, then that committee is not right, and we must change it so that we have the people that matter. Every report that I've read in preparation for tonight and for the debate last September said the voices of those who are going to live on the islands are the most important voices. And that's who we should be listening to. And finally, in relation to the producers' organisation, or the group that attempted to comply with the rules, play by the regulations, and they didn't succeed. And they were refused on the 20th of September 2019 because of a criterion. Now, I certainly understand if there are mandatory criteria that would have excluded them if they didn't reach that level. But sir, at the very basic, that should be all very apparent to any group that's coming forward to be an organisation, an islands fisheries producer organisation. At the end of the day, we want small groups, we want small businesses, and we want cooperatives on the ground. They are the backbone of any country. So, Minister, I hope that you're listening tonight, and I hope at the very least out of this that this will go to third stage and that you will meet the groups on the ground. Now, you mentioned forums. Quite clearly, they're not adequately reflecting the opinions on the ground. Because if they were, Minister, you're shaking your head, we certainly wouldn't be here at 7:15 on a Thursday night unless we're reflecting what people are telling us on the ground and asking us to say in the Dáil.
Deputy Kenny, you haven't indicated, but I assume you want to address this matter.
Certainly. Thank you very much, Corla. And first of all, I'd like to thank the committee for the work they've done, and the chairperson of the committee, Pat Deering, and the staff. The report is an excellent piece of work. It sets out a lot of the issues that we expected to come out in respect of that. And I also want to thank the contributions here this evening from all the various deputies around this matter. In truth, the Minister's response, is somewhat disappointing, and I do acknowledge that he did write to me, which I think other people who have had problems with money messages didn't even get that acknowledgement, and I do appreciate that, and appreciate that he is engaging and is interested and is trying to come up with a solution in respect of this. But I certainly feel it is falling well short of where we need to be. There there has been, and others have spoke about the island fishing communities and people living on the islands. And the few times that I visited an offshore island, I was always struck that while they were so much a part of the nation, they were also apart from the nation in a very physical manner. And we can all say we're isolated and we're in rural areas and we can't get to us or whatever, but nobody is as isolated as a person that's a couple of miles across the sea to get to them. And I think there has to be an acknowledgement of that huge disadvantage that people that live on the islands have. And, Deputy Connolly mentioned about equity, and equity is at the core of this. And sometimes in order to achieve equity, you have to treat the group in an unequal manner. You have to give them advantage that others may not have because they exist in such disadvantage. And that's really what is at the core of this, Minister. And it was recognised by the previous committee when they produced the report in 2014, and it was in response to that that this bill is with us. Now, I know there has been some positioning in regard to the department, particularly saying that every fishing vessel has to have a licence already, and they shouldn't have to have a second licence. And if you want to change the word and call it something else, a fishing opportunity or whatever, that's fine. We're not hung up on words here. And I think the opportunity to do all of that would come when we get to third stage with this piece of legislation. The issues that have been brought forward by the various groups that came in, and I also want to thank all of the organisations that came before the committee and gave evidence and were in generally very constructive. Many of them come from their own set positions because they're looking after their own corner, and many of them at the same time were generous enough to recognise and understand that island communities also need that little bit of special attention and that extra advantage that they don't presently have. Because the persons living on the islands, and I also got very friendly with one man who lives quite close to me now and was born and grew up on the island. And he says that, the one thing that you always knew you had was the bit of fish. You had nothing else, because there was no other opportunity to make a few pound. But you had the bit of fish, and they could go out and they could get in the boat and they could get some fish. And the other thing that he always absolutely drives home to me is that the way those fish were caught and that tradition of doing it that way is something that had a unique selling point to it, apart from the fish that was caught by a super trawler in a big net. And certainly speaking to, and I've spoken to some of the celebrity chefs about that particular idea, that particular niche market there's there for the fish that would be caught in that manner. If it were done properly and marketed properly, it does have a particular story about the food that I think is something that we have often talked about, both from an agricultural as well as a fishing. It's in the strategy, and that's exactly what we need to do. And my point is that this piece of legislation feeds directly into that strategy and into how to do this if we can do it properly. Now, the big, if you like, stumbling block we have here is that the Minister and the Department in particular are saying that it is in breach of EU legislation and that we can't do it because it is illegal. And yet, and it has been pointed out by others, it has been clearly said by the European Union by the European Union that that's not the case. And in fact, in a question that was asked of Commissioner Vella, he was asked, can the Commissioner clarify EU regulations can provide for Member States such as Ireland to implement a licensing system that would allow for a heritage licence to be issued to island fishermen conducting small-scale artisan fishing in order to facilitate the continuance of traditional fishing practices on Ireland's offshore islands, with specific reference to fishing within the 6-mile territorial limit, including the Blaze Line. The question was asked of the Commissioner, and the answer he gave was that in line with Article 6.1 of Regulation EU 1224/2009 establishing community control systems for ensuring compliance with the rules of the common fisheries policy, a union fishing vessel may be used for commercial exploitation of marine biological sources only if it has a valid fishing licence, which they all have and have to have in order to do it in the first place. Fishing licences referred to in Article 6 of the Control Regulation shall be issued, managed and withdrawn by Member States of their fishing vessels in accordance with this regulations. Indeed, small-scale and artisanal fishing, including by island fishermen using traditional fishing practice on Ireland's offshore islands, is to be considered commercial exploitation, and is therefore it is up to the Member State to decide whether they wish to put in place a licensing system such as mentioned by the Honourable Member. In any case, the issuing of licences must comply with the ceiling set out in Annex 2 of Article 23 of the Basic Regulation for the Common Fishery Policy. That is about the quota system. Now, So we're exactly on the same page in regard to that. The Commissioner is saying you have to have a licence to have a boat for to go out to fish. You also have to have access to quota. And it is up to the member state as to how they divide that quota and how they work out the solution. And that's what we need to be able to do. And Minister, this is not, some kind of a Rubik's Cube that we're not able to solve. We can come to a solution here if we can sit down and work it out. But unfortunately, because of the notion that we need to have a money message in respect of this, we're blocked. And I feel, Minister, that at this point, because we're talking about, I think is there 2,700 people at present living on the islands. We're talking about a small portion of the Irish population who need a special advantage because of their isolation and their special status, if you like, within our economy and within our society. And I think we have it within us. We have the genius within us to work out a solution here. And I would appeal to you and appeal to the Department to come back here and look at a solution that can be found. This particular piece of legislation is not perfect, and I'm not suggesting it's perfect, or none of the speakers here tonight suggested it was perfect. But it is enough to build on in order to provide a solution which will help those people who so much need help. All of the islands, and it was pointed out in various reports and by various witnesses that came before the committee, that the island population is continual decline all the time. And that the only way, the only chance they have of being able to sustain themselves if something unique can be put in place for them. And I absolutely respect and understand that coastal communities, and particularly small-scale fishers in the coastal communities, have similar problems. But they have other options that the islanders don't have, and that's what sets them apart and makes them different. So I think in the context of all of that, Minister, I would appeal to you to go back, look at the money message, and perhaps the Cancórla can advise and can assist us in respect of that, because there are a lot of these money messages there at the moment, and I think we do need to be coming up with a solution in respect of them. But in this one in particular, the burden on the state, in order to be able to provide this mechanism to give that advantage to a small sector of people who are so hugely disadvantaged, would be so tiny that I do not think it is worthy of putting a block in its place, as government has done on this occasion. And I acknowledge, Minister, your commitment and understanding of the fishing sector is probably greater than mine. You're much closer to the sea than I am. But yet, we find us in this position that we're on two opposite sides of this, and we should not be. We should be together on the one side here to work out a solution and move forward to ensure that we can deliver for this small sector of people. And if we are able to do something which will work for that, then we can look at the other inland fisheries, small fishing communities, which are also under strain and under stress, and see what can be done there. But there does need to be a unique solution for a unique set of people who live on the islands. And finally, I would just like to also offer my appreciation and great thanks to Seamus Bonner and Enda Connelly and others in the island organisations who have done so much work and have really put so much pressure on in order to drive this forward. And Minister, I would finally ask you to, again, as others have asked you, to sit down and talk to and meet with the island fishery organisations and talk to them about this and come up with a solution, and bring your officials there, not from the point of view of what they can't do, but from the point of view of that they can do. And I think if we could enter into this in a can-do attitude, we can come out of it with a solution.
Minister, would you like to respond?
Cancórla, I welcome all of the contributions. I just want to make a few observations in response to points that have been raised. Deputy Kinney, in his concluding remarks, and I think Deputy Penrose, laid the blame in a way at bureaucracy, and our job was to find a way, I think was the line used by Deputy Penrose. And could I just say two things? First of all, in terms of the engagement which I've had with all the officials in my department, there is an absolute commitment and an ongoing endeavour to maximise the opportunities for the smaller players in the fishing industry. And I think the evidence is there, both from them and my own commitment in that regard. And I have to say, in the context initially of all my engagement with the fishing industry, it was with the established POs, and Deputy Pringle would be very familiar with amongst the most powerful of those in his own backyard. And in fairness, one of the last acts of my predecessor was establishing the NIF and the RIF, the National Inshore Fisheries Forum, and the various regional fora that feed into that. And participants in the regional fora are the island people. And as a consequence of the voice that they have been given, they now sit around the table as equal partners. And that's as it should be, because in numerical terms, in terms of boats on the water, they are far more significant. But in terms of the economic opportunities that were available to them, they are minuscule in comparison with the larger established producer organisations. And except both have legitimacy, and both, make a living in a difficult environment and operate within pretty established circumstances and regulations and laws and directives and common fisheries policy and all of that. But there is absolutely a willingness in terms of officialdom that I've engaged with in my own department and personally, and with my predecessor, in terms of maximising the opportunity. And I think, Deputy Pringle, you would know this, the NIF and the RIF have been, in my view, if I pardon the pun, represent a sea change in terms of the voice that sector now has. And that has given rise to, after public consultation, which it has to be said in this chamber, was strongly resisted by some, has given rise to significant increase in opportunities for the smaller fishermen, including island communities, on a par with other smaller fishermen in the inshore sector. They now have a multiple, financially and in terms of fishing opportunity, of what they previously had. A multiple of it. In overall terms, I think the figures are an increase of 62% in the opportunity they have now because of the decision taken to exclude the large boats from the inshore sector. Now that, by any stretch of the imagination, is really, really significant in both volume and value terms. If you want other evidence of commitment, the EMFF, the European Maritime and Fisheries Fund, the flags, which is the marine and coastal community equivalent of the leader groups, which are delivering significant financial opportunities and assistance to the inshore sector and to the island communities. The scheme of assistance operated through BIM for smaller fishermen to invest in their own storage capacity, gear, etc. That's particularly targeted at supporting the smaller sector. So there have been a range of initiatives which I believe have stemmed from the fact that the inshore sector, through the NIF, are now an equal partner. Now, Deputy Lawless, I really don't want to go into the points he raised about being sold out in 1973. All I would say is our industry today is multiple the size of the industry that existed in the 1970s before we joined the European Union. It is multiples the size of the industry that existed then. And in fact, if you look at the Brexit issues that are serious challenges for our fishing industry, one of the benefits of being a member of the European Union is access to other waters that we now have. And the pelagic sector, 60% of the opportunities we have for the pelagic industry are caught in UK territorial waters. That's a benefit of being a member of the European Union, the common fisheries policy, access to community waters. 40% of our second most valuable stock comes from UK waters. And that's a serious challenge, but it does reflect the fact that the UK gave us opportunities. Our industry prior to joining the European Union was largely an inshore industry. Maybe that's an overgeneralisation, but it was substantially an inshore industry. It's now a very different industry in its manifestation, but it is, in value and volume terms, much bigger than it was prior to joining the European Union. I have concerns, Deputy, about the bill on a number of fronts. I don't intend to go into all of them here, but I'll tell you one of them that I have significant concerns about. And, we take a different view as a nation than a lot of other countries have in terms of the common fisheries policy. We have steadfastly resisted the idea of privatising our quota. We have steadfastly resisted the opportunity. And I am somewhat surprised by some of the contributions that I've heard who talk about, and this would be the thin end of the wedge, privatising the quota. It's talking about, no, you are talking about giving quota to individuals. And be careful what you wish for, because many in the industry, and you know this, Deputy Pringle, many in the industry would love to see the quota privatised. And it's something every government since we joined the European Union has steadfastly resisted. And it would be a dangerous foot in the door to privatisation of our quota opportunities if the contents in this bill were adhered to. I just want to take issue with the point made by Deputy Connolly about the government's review of islands policy, etc. It is an interdepartmental group, and all of the relevant actors in all the government departments will go to the island communities and listen to the island communities, and that's as it should be. And that's the whole purpose of it, that those cross-government departments will engage with those communities, and not as the Deputy seemed to present it, as people talking to themselves. In fact, it's being launched, I think, this weekend down in Sherkin Island, so there will be listening to the island communities. I would also say that, in fact, in the context of my own department and the Common Agricultural Policy, in terms of things done by the government to support island communities, there has been a very significant increased financial support to farmers, island farmers, under the Common Agricultural Policy, significantly higher payments available to them than to their colleagues on mainland. And that's as it should be, because there are additional costs. So I think our record is defensible. I do appreciate the debate that the bill has promoted, and it has brought into sharp focus the needs of the smaller man or woman in the fishing industry. And it has, in the debate that it has generated, I think delivered real tangible results, of which I'm quite proud of as a minister in government to have delivered upon.
If there's nobody else offering at this stage, the question is that the motion be agreed to. Motion agreed? Motion agreed. Lishin Taganod na Shaktana Taga Kandera Agus Tandol Ratlo, the Anmarchakun Egadochlog, Gramma Diver Fad.